Now, you can understand why you can't have many mandates in a competitive system, because if California mandates rules that people don't like, those firms then will just incorporate somewhere else. So you can only have mandates that in some sense don't bite, and that is that there are things that investors want, like, you know, we might say having a board or a centralized board or a duty of loyalty and the like. So you can't get customization in a mandatory setting of federal regulators. So I think that's something that we want to think about. If we bring back the fact that the business environment is dynamic and constantly changing, you want the flexibility, right, to be able to move quickly. And just one example comparing the state and the federal level, if we looked at sort of how quickly does the legislature act to reverse a decision that is seen as undesirable, on average, the Delaware legislature acted much more quickly to reverse decisions, like 1.5 years. Bill Estridge did a study once of Supreme Court reversals, and they take much longer by Congress. You know, now that may or may not be a good measure, right? Because maybe these are bad decisions or good decisions that are being reversed. But we have to remember that it's much longer to act if you have something that's wrong on the books. So let me conclude with those as some of the reasons that get lost sort of in the debate about the federal government versus the state, is to remember why why we want to emphasize having the states be the primary regulators of corporations from the benefit of having competitive federalism.
Very nice. Thank you, Professor Romano. Our next speaker is Cornish, Con Hitchcock. He is the principal of the Hitchcock Law Firm in Washington. He received his BA from the University of Chicago in 1972 and his JD from Georgetown in 1975. Prior to opening his firm in 1998, Mr. Hitchcock spent 17 years at the Public Citizen Litigation Group, perhaps the foremost litigation group of its type in the nation. Mr. Hitchcock has been lead counsel in over 20 federal and state trial courts. He has argued over 50 cases in 9 federal appeals courts and also in several state appellate courts. Finally, he has argued 5 cases in the United States Supreme Court, and we look forward to Mr. Hitchcock's remarks.
Thanks very much, Judge Hardiman. I appreciate that nice introduction. I may be the designated heretic on the panel here today. My experience in recent years has been working mostly with labor and public pension funds that are institutional activists in the shareholder arena, although I add that whatever I say today is my own thought and not necessarily that of anyone I work with. My approach to some of these federal issues comes from a different perspective. Back when I was at Public Citizen in the 80s during the drive to deregulation, the federal government stopped regulating in a number of areas about health, safety, consumer protection, and the states moved to fill the gap. And not surprisingly, as many of you know, there was strong resistance to that, and there mushroomed the area of preemption law and preemption litigation. What did Congress mean? Or my favorite doctrine, implied preemption. Yeah, we know Congress didn't say it was preempting, but if you hold the statute up to the light at the right angle, it's obvious that's what they really meant. And I found this whole idea of state versus federal frustrating because there was really a lack of some useful organizing principles that would help one try to decide that, at least at a public policy level. As I talked to people, friends on the other side of some issues, one of them once said to me, "Oh, Con, it's really simple." This is somebody with a trade association. If our members are for preemption, we're for it. If they're against it, we're against it. Another friend said, well, back in the Carter years, I was a fan of states' rights, but in the Reagan years, I like uniform national federal regulation. So I've tried to think about these issues over the last umpteen years, I admit not with the rigor of a full-time academic, but more from the perspective of somebody on the shop floor of the sausage factory where policy is being made. And I have to confess that that has made me skeptical of absolutist judgments about state law is always better or presumptively better than federal law on a given topic. I think it tends to be situational. So let's move from that background to today's topic. First, I want to question the notion that state law has reigned supreme for hundreds of years. The federal government has displaced the states in antitrust law for 120 years, securities law for 75 years, and let's not forget that ubiquitous instrument of corporate governance, the Internal Revenue Code. I believe, and I think it's true, that there are not now, and have not for some time, been any generally agreed constraints on what Congress should or should not regulate when it comes to corporate governance, except maybe the principle that, yes, companies should have a charter and they should disobey state law. They should obey state laws. One may disagree with that that's the way the world works. Now, my own view is I find myself aligned with those who view state corporate law as being preeminent only to the extent Congress is willing to allow on a given vote. I think we know that if the federal government wants to seize an issue, it can do so. Is that a bad thing? Let's look for a moment at the current system, and we've talked about Delaware, and whether you view this as the dynamic as a race to the bottom or a race to the top. I think most people would agree that Delaware has won the race, has retired the crown, and has not given it back. Let me ask this question. If you wanted to create a corporate governance system today for a post-industrial global economy, what would you use? Would you choose the current model? Would the obvious model be to entrust legislative power, the most significant legislative power, to a body that is accountable to fewer people than the Fresno County, California Board of Supervisors or the Bergen County, New Jersey Board of Freeholders? The way things are now, Delaware has a smaller population than more than 50 counties. But nonetheless, the Delaware law represents the default standard, even though there are many stakeholders who don't have a say in the people who are making the laws. Now, I'm bringing this up not to be critical of Delaware, although certainly others have from longer than recent debate. I could not resist, there was a quotation from 1899 when Delaware started aggressively competing in a law journal that criticized the state as, quote, a little community of truck farmers and clam diggers determined to get her little, tiny, sweet, round baby hand into the grab bag. Nothing I say today will be that pointed. But during the 1970s, William Carey, many of us used his casebook on corporations, and he was an SEC professor, was equally pungent and criticized Delaware that, quote, as a pygmy among the 50 states, prescribes, interprets, and indeed denigrates national corporate policy. Now, my goal here today, and I want to be clear what I am and I'm not saying, is not to say that Delaware law is bad or the people administering it are bad or that it ought to be replaced by a single federal statute. What I am saying is let's look under the hood. Let's see if we like how the engine is running. Let's see if we think it needs a tune-up. The problem, I think, is that there's a profound tension with the current structure. As pointed out, Delaware is home to half the S&P 500 and many other companies and generates revenues that are about 1/3 of the state budget, or nearly $3,000 per household. Now, the tension is obviously state government likes that situation. They don't want to regulate in ways that might drive companies elsewhere. On the other hand, there's always the ever-present threat that Congress might step in if it thinks that a federal rule is appropriate. Witness Sarbanes-Oxley, as has been talked about. And the more homogenized corporate law becomes, the less incentives there are, fewer incentives there are to choose one state over the other. The title of today's panel talks about creeping federalization, emerging federalization. There are those who've said, well, the reason that that only is now appearing is that Delaware has been very adroit previously in reading the tea leaves, and the statutory law, which Professor Romano said is enabling, and the case law have tended to some extent, track that. I mean, poison pills came along and were approved at a time when there was a lot of concern about corporate raiders. More recently, with shareholder empowerment, the statute has been administered in a way that is perceived as more shareholder friendly. So I think the issues will play themselves out. We'll talk about proxy access and majority voting and some of the others during the particular debate. But from where I sit, at least, watching as they unfold, I don't think one should view state law as somehow a citadel that should never be breached. I think it's more useful to look at the issues in terms of their own merits and decide on their own merits if they are appropriate, and if so, whether appropriate as a matter of federal law or state law, and that is a more diffuse inquiry. Thank you very much.